Hello and welcome to Legal Briefs, XRP edition. This week saw the filing of the XRP holders' letter seeking intervention into the lawsuit, and quickly thereafter responses from both the SEC and Ripple, and this battle is getting amazing. I'm like a kid at the movies watching this back when we used to go to the movies. And this week we are going to take a look at, among other things, how Ripple is actually using the XRP holders' motion to attack the SEC's position, and well, just watch this.
Okay, Thor, hit me.
Just imagine, Thor is the XRP holders and Iron Man is Ripple.
We all know who the real heroes of the movie were. Get out of there.
Yes, dear.
Don't worry. She's got help.
Hello, this is attorney Jeremy Hogan, and let me tell you what's really going on here. The SEC is being put between a rock and a hard place by the XRP holders' motion for intervention and Ripple's response to it. And we're going to tell you about that and also the possibility of resolution of one of the key parts of the lawsuit and what that would mean for you. Stay tuned, you don't want to miss it. And that is how it's done.
Okay, today we are going to look at the motion to intervene by the XRP holders with attorney John Deaton and the responses that were filed by Ripple and the SEC. Now, the SEC has painted itself into a bit of a corner here, and I'm going to tell you the easiest way out for the SEC, which essentially involves letting go of one part of the case, which is the most important part for you. Now, it's subtle, but I'm going to show it to you. But before we begin, please remember not to rely on me for legal advice. If you need a good lawyer, you have to pick one of these out of a lineup. Tell me which one you choose. I am a lucky man. In any case, as you may know, on March 19, attorney John Deaton filed his letter motion on behalf of over 10,000 XRP holders to intervene into the lawsuit, which means that those holders would essentially become a party to the litigation. Now, this would grant them the ability to get involved in discovery, and perhaps most importantly, for them to submit a motion for summary judgment to the judge in which personal statements by individual XRP holders could be submitted to show the judge how this lawsuit by the SEC, which is supposed to be protecting them, is instead hurting them. As the motion says, quote, by alleging that XRP sold and or distributed by Ripple in the present day are unregistered securities, the SEC is implying that all XRP constitutes unregulated securities, including the XRP in the accounts of XRP holders. Now, this intervention is a big problem for the SEC for that exact reason. The SEC's whole purpose is supposed to be to protect the purchasers of XRP, and instead you have 10,000 of them coming forward and saying, you're actually hurting us. No, thank you for the protection, we'll pass. But before we get to that, let's take a quick look at the bind that the SEC has been put in. Ripple, in its response to the motion to intervene, in essence, uses the motion to intervene to highlight some of the most important issues facing it. Now, as I've said for the last month or so, Ripple must argue that every sale is a separate event, and by doing so, differentiate more recent sales from those in the past. Now, the SEC, on the other hand, must and is arguing that all of the sales were one kind of big 8-year offering or one big sale, and they're going to try to lump all the sales together. So, knowing that, see what Ripple is doing here. First, in section 1, Ripple highlights the damages caused to XRP holders by this lawsuit, and also, something that is super important, look at these two sentences. Quote, based only on unproven allegations, the SEC has effectively shut down trading by XRP holders over exchanges in the United States, and it has done so on the basis of a complaint whose theory of liability is ambiguous at best, and at worst, deliberately misleading so as to arrogate for the SEC optionality as this litigation progresses. Ugh, I don't like how that last part was phrased. Arrogate, really? But here's what they are saying. Ripple is saying that the lawsuit by the SEC was so vague and conclusory that the SEC was trying to leave itself two paths forward in the litigation. It's so vague that the SEC can say they are arguing that all XRP is a security, or if it so decides, it can say, oh no, Judge, we would never suggest that individuals are selling unregistered securities because that would be ridiculous. We're supposed to be protecting the people. The SEC is trying to have it both ways. They're trying to leave it open to argue both both positions, and Ripple is absolutely correct here. That is exactly what the SEC is doing, because the last thing the SEC wants is to get into being forced to argue not only that the numerous sales by Ripple were sales of illegal securities, but also to have to argue about the billions of smaller transactions in the secondary market. The SEC just wants some vague ruling that sales constitute unregistered sales of securities and give the judge some vague promise. And don't worry, judge, we won't be going after the secondary market. Of course not. We're the good guys. We're sticking up for the small people, judge, and hope that the judge goes with that. And what Ripple is doing here very effectively is they are piggybacking off the motion to intervene and calling out the SEC on this and saying, and this is in section 2, they're saying, you have to choose. Are you alleging XRP is kind of inherently a security, or is this lawsuit only about sales by Ripple and Garlinghouse? And here's how they say it. Quote, the SEC now has a chance in the face of the putative intervener's letter to confirm that its suit is not intended to affect the secondary retail market for XRP in the United States. Despite some broad language in the amended complaint, the SEC has at times suggested that its theory of liability is indeed more limited, such that the secondary market sales and other transactions in XRP would not be subject to the federal securities laws. So, can you see where this is heading? First, Ripple is cueing the court in that each sale is different. Now that helps them. And with even more focus than that, Ripple is basically arguing, wait for it, hashtag relist XRP, which is where I was kind of hoping they'd take it. And then Ripple says this, which is brilliant, quote, reaffirming this narrow theory of liability and clarifying that the SEC does not seek to establish that XRP is per se an investment contract would minimize any interest interveners have in the outcome of the litigation. Love it. Hey SEC, you don't want this motion to intervene granted? Then just confirm to the court that you are not trying to establish that XRP is per se a security, and maybe then we might agree that there is no reason for them to be involved. Perfectly reasonable, but also the perfect trap, or maybe it's a subtle outline of an offer of settlement. Now this is very subtle, but huge, which is why I like it so much. What Ripple is suggesting essentially is a settlement in which the SEC agrees to let go of all current and future sales and only continue the litigation as to the pre-suit sales. Now how is that? And why do I have some evidence that the SEC might be going for it? And what's it mean for you? Here we go. So, as we know, it's the sale of XRP that the SEC regulates. If the SEC stipulates to what Ripple is suggesting, that it's not going to argue and is not arguing that XRP is per se a security, then each sale would have to be looked at on its own and in its own facts. How was it sold? What promises did Ripple make about it? How decentralized is the ledger? What use cases are functioning? And then you would have to look at each sale individually. Now that would be the law if the SEC agrees. And if that is the case, then this lawsuit cannot possibly capture future sales because we can't see into the future, meaning the court won't have any facts about future sales. The SEC's agreement on the record to this proposal takes future sales, sales from escrow, out of the litigation. In fact, it probably takes all pre-litigation sales out of the picture because, of course, there are only allegations in the lawsuit up until it was filed. This de facto settlement would mean the secondary market would be in the clear, XRP holders would be in the clear, and that Ripple would be able to continue to fund its business with XRP sales, and the litigation would continue only in regards to sales of XRP between 2013 and December 2020 when the lawsuit was filed. Ripple has already said that is the very thing they want. And what about the SEC? Well, let's take a look briefly at evidence they might possibly be on board for this. Look at the first paragraph of the answer. Quote, on December 22, 2020, the SEC filed this action alleging as relevant here the defendants Ripple Labs Inc. and Ripple's two CEOs engaged in unregistered offers and sales of XRP from 2013 through December 2020 in violation of Section 5 of the Securities Act of 1933. At the heart of the SEC's case is its contention that defendants offered and sold XRP as investment contracts and therefore securities under SEC v. Howey. Okay, so what do you see in there? Take a good look. I see the past tense. Quote, they sold. Quote, offered. And more importantly, look at how the SEC outlines its lawsuit allegations to the judge. Quote, Ripple and two CEOs sold XRP from 2013 through December 2020, close quote. What about the and continuing or will continue sales or any such language to that effect? It's not there. Could it be sloppy pleading? Possibly. But if not, maybe the SEC is signaling its willingness to throw out anything about January 2021 and into the future sales and just focus on 2013 through 2020. And would that be good for XRP? Well, you tell me. We'd have clarity for exchanges, we'd have sales of XRP from escrow continuing, and we'd have Ripple possibly looking at a big fine if they lose. And let me suggest that that's not a bad thing if I put myself in the shoes of the SEC lawyer right now. I, as the SEC lawyer, my very existence is supposed to be to protect individual investors. And here I have this big case with lots of eyes on it, and I have tens of thousands of people basically wanting to get into the litigation against me. I mean, that's like you're a cop and you show up to arrest a guy and all the victims start shouting at you to leave him alone. Now, I have to give props to the lawyer here. He does a good job of downplaying this by telling the court that there's also a lawsuit against Ripple for selling unregistered securities, and that kind of negates the weirdness somewhat, but it's still there everywhere, highlighted by the fact that most of the cases the SEC cite to in its letter against the intervention reference cases where the intervention by the purchasers of securities that they wanted to jump into the lawsuit and go after the sellers of the unregistered securities, not the other way around, not against the SEC. So this whole case is butt-face backwards. But in any case, let's say the SEC does not take the olive branch from Ripple and wants to charge forward with the current and future sales in the litigation. Now, what do I think will happen with the motion to intervene? Well, it's hard to say because the lot is left up to judicial discretion, meaning the judge can do whatever she wants. But if I was the judge, I would probably go along with the suggestion contained in Ripple's response. Quote, but defendants take no position at this time as to whether intervention or some other more limited participatory rights, such as an elevated amicus status, are appropriate, close quote. To allow 10,000 litigants into this type of case, even as a class, might really trip up this litigation. An amicus is an interested party who can submit a brief laying out its position so that the judge can take that into account without the amicus actually being a party to the lawsuit. Now, this would be a good resolution because it gets the XRP stories in front of the judge without any delays in the proceedings. And so you can see that the motion for intervention really was the lightning powering this latest Ripple attack and perhaps resolution to the most important aspect of the litigation for you. Remember, never give in to feelings of powerlessness, but remember the words of Christine Whitman: anyone who thinks that they are too small to make a difference has never tried to fall asleep with a mosquito in the room.